Welcome back. Let's now bring you a report on some of the challenges trailing the judiciary 59 years after independence.
Just like the other arms of government, the Nigerian judiciary came into existence before the country attained self-rule, and by independence in 1960, it attained the status of an independent arm of government. This led to the establishment of the Supreme Court as the apex court, with Sir Adetokunbo Ademola becoming the first indigenous Chief Justice of Nigeria in 1958. The military era, however, witnessed wanton disregard for the rule of law and democratic principles, as the military government treated the judiciary as if it were an integral part of the civil service. The period also witnessed indiscriminate dismissal of judicial officers and open disobedience of judicial pronouncements. The return of democratic rule in 1999, however, brought to the fore the vibrancy and courage of the judiciary, as several landmark decisions were made by the court. This new vigor was attributed to some unique provisions introduced by the 1999 Constitution, including those providing for the establishment of two independent regulatory institutions, the National Judicial Council (NJC) and the Federal Judicial Service Commission. In spite of these positives, however, some major challenges persist. One of such is the lack of independence arising from the judiciary being tied to the apron strings of the executive arm of government, as recently alluded to by the Chief Justice of Nigeria, Justice Tanko Muhammad.
The annual budget of the judiciary is still a far cry from what it ought to be. The figure is either stagnated for a longer period or it goes on a progressive decline. The only thing I can do at this juncture is to plead with all concerned to let us enjoy our independence holistically. If you say that I am independent, but in a way, whether I like it or not, I have to go cap in hand asking funds to run my office, then I have completely lost my independence.
The judiciary has also had to grapple with accusations and counter-accusations of bribery and corruption against judicial officers.
Our focus has been on reinventing our processes, providing speedy and quality administration of justice, strengthening our structures from the Supreme Court to other courts of records, and stamping out corruption from the system. If any judge is found wanting and there is evidence, please write your petition to the National Judicial Council immediately for prompt action.
Attempts by the federal government in recent past to tackle issues of graft through the arrest and trial of some judges have failed to yield any satisfactory result, as some of the judicial officers whose homes were raided in October 2017 by operatives of the Department of State Services have been absolved of the allegations. For those still in court, the cases are moving at a very slow pace. Apart from corruption, delay in court proceedings, other problems plaguing the third arm of government includes failure of other arms of government to obey judgments of courts, high cost of litigation, over-reliance on legal technicalities, prison congestion, and poor funding.
Nigeria as a nation needs to look at the process of appointing judges into our various courts. We must review the process to be sure that those that are appointed are those that are really ready for the job, because it's not something that it's not like every other occupation. It's something that is what requires, it's a profession that requires what I call people of integrity, people who are competent, people who are hardworking, and those that understand that judges are like people standing in the place of God.
They should employ some academics, very brilliant academics, and some specialists in different areas of commerce into the Supreme Court. If it means amendment of constitution to increase the number of judges or justices at the Supreme Court, they should do that. Because right now what we are getting is you get 2-3 years adjournment. That's another area they need to work on. In fact, they might have to separate or have departments in the Supreme Court. This idea of having just one Supreme Court is not working, because cases are there forever.
Going forward, the expectation is that all stakeholders must play their role to effectively tackle the challenges confronting the administration of justice so that the judiciary can continue to live up to its constitutional and historical role as a bastion of constitutional democracy.